Have you or a loved one been accused of sexual assault? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk about sexual assault laws in Texas. Maybe you or a loved one is facing a charge like this, and maybe you didn't do anything wrong. Maybe these are false allegations. Maybe you were in a relationship with someone and that relationship went south, and now all of a sudden they're trying to claim that prior relations that you had with them was somehow not consensual and that they're trying to claim a rape took place. Well, I want you to know what the law is, and on this video today I want to break down the ins and outs of sexual assault laws in Texas and provide you an opportunity to get out in front of your case. And by the way, if you wait around to the end of this video, I'll also provide you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Now, outside of a murder charge, sexual assault is one of the more serious charges that you can receive in the state of Texas. So much so that many times it feels kind of unfair when you're defending a sexual assault charge because the police are very prone to just take someone's word. You could have someone say, hey, this guy did this to me, this person raped me or sexually assaulted me, 6 months ago, and I just didn't come forward with it. There may not be any physical evidence. There may not be anything else to substantiate whether or not any of this took place. And yet the police will routinely rely upon the word of an individual as the basis for probable cause to bring an arrest warrant and bring charges against someone. So if you are facing these type of allegations, listen, I understand you have to be pretty intimidated by it. And it's frightening to know all this is being bearing down on you when you didn't do anything wrong. Well, one of the things we need to know is let's first identify, maybe you haven't been arrested yet. Maybe you received a phone call from a detective wanting to speak to you about a sexual assault allegation. Well, first of all, let me just tell you this. That detective is not going to presume that you are innocent. In fact, that's not really their position. That's not their job. Their main position and job is to try to name a suspect, gather as much evidence as they can, and establish what they can on that low level of required evidence to put together a probable cause warrant. So what happens many times is be aware of the fact that there are a number of type of what I would say creative tactics that investigators use in order to try to gather this evidence when they choose to believe an alleged victim. One of those things is they collect any evidence, any physical evidence of the alleged assault by examining the victim, and that's normal. That's a normal thing to do. And they should do that usually as soon as it's been reported. But then they will also look to have a forensic interview done where they're going to examine specific information from the alleged victim, and you need to look at it. I'm going to tell you this, your defense attorney needs to look at it very carefully. You want to make sure, are they being coached? Is that interview truly the alleged victim telling their story, or is it a detective leading them in the direction they want for them to say what they want them to say? Also, sometimes detectives will try to encourage the alleged victim to try to gather text messages, cut and paste different things together as part of an attempt to try to establish that someone maybe incriminated themselves. Like we find this happens all the time. You'll have somebody that will just take a text message out of context and try to use it to claim that it is somehow a confession. Somehow someone's admitting to something based upon this very vague text message. So be aware of that because those are some of the things that they'd be looking for. So many times you're going to be the last one to know that you are being investigated for a sexual assault allegation. Law enforcement is likely going to gather as much evidence as they can before they ever reach out to you. So this is really important for you to recognize. Once a detective actually calls you, they've already gathered everything that they wanted to gather from the alleged victim and from any other evidence they were able to establish. Please recognize this. When they call you, they are not your friend. They do not really want to hear your side of the story. Instead, what they look to do, the detective is wanting you to be able to come in and sit down with them, and they are not going to just let you say what you want to say. They are going to interrogate you, okay? And what does it mean when we say interrogate? Interrogate means they're going to be asking you leading questions, questions that already presuppose an answer. Something where they're leading you down the road to say certain things to back up a story that they've already put together. So please be aware, if you choose, generally, Anytime someone gives me a call, I say, you need to really think seriously about whether you want to go in and have a interview with a detective, because there are many things a detective can do under the law that might surprise you. Number one is it is perfectly legal for the police to lie to you during an investigation. And in fact, they do it all the time, as long as they don't do it in such a manner that causes you to be placed under some type of duress or coercion in order to give a confession. They can lie to you all day. They can make up all kinds of things. They can claim they have certain evidence and they already know the result, and they don't. So be aware of that. You're not playing on equal ground when you speak to the detective. But it doesn't go both ways. If you lie during your interrogation, now they want to use it against you and claim that your misstatement or your lie is proof of your guilt, right? So understand that's how you're going to be graded. So even if you tell the truth in an interrogation, here's the other problem. You say, well, I got nothing to hide. I'll go in and explain to them I didn't do anything wrong. Be careful. Let me ask you a question. Have you ever been misunderstood? Have you ever been misinterpreted? How many times have you just had a conversation with a friend or a family member, and that person, you thought they understood what they said, and you find out they completely misinterpreted it and took it in a whole different direction? Now imagine a detective who is looking for information to incriminate you. So you could be sharing the truth with this person, and they could choose to misinterpret it or misconstrue it. Now it's your word against their word. Who's the judge going to believe? Who's a jury going to believe? Be aware of that. That is a very serious thing to consider. Also, inconsistencies in your statements listen, if you were to give a statement one time and then later you said something else, it's common for people to say something and it may be a little bit different because of how someone recalls it. But even in innocent, small little misstatements or inconsistencies could now be used against you. And even though you might have said them because you were nervous in the interrogation, now it looks like you're guilty, right? So that's the pre-charge, okay? That's before you ever would potentially get arrested. Be aware, speaking to a detective, if you do it at your own peril, okay? Now, let's talk about the definition of sexual assault in Texas. Under Texas Penal Code, Chapter 22.011, sexual assault includes the following. If you have sexual abuse of an individual who cannot give their consent due to a disability or diminished mental capacity, intercourse or penetration without that individual's consent, sexual intercourse or contact with a minor. A minor is defined as any person under the age of 17 in Texas. If it is forcible and violent, then regardless of whether that individual gave consent, if it extends beyond the bounds of that consent, that could be sexual assault or coercive sexual acts. Okay, so in Texas, if physical violence was used or threatened in order to get the defendant or to get the alleged victim to do what the defendant wanted, or if the victim was unable to resist the act that was involved here, then Texas basically looks at that situation and says there was no consent. No consent was given, okay? So what if the individual was in a position of power or a position of influence? Maybe they had charge over taking care of an individual, or they had a position of influence over them. There, they could also be charged with sexually assaulting that individual. Texas considers that the victim was not able to give consent. Good example of this happens all the time, is what if you have somebody that's like a teacher and a student type situation, even if they're of age, right? Well, understand that because of the relationship that's involved, there is a presumption that there is some type of coercion or inability to provide consent by the student because of the relationship that exists. Okay, now, aggravated sexual assault. Sexual assault becomes aggravated sexual assault if any one of the following occurs. If the defendant attempted to cause or caused serious bodily injury or death to the victim, the defendant placed the victim in fear of losing their life, being kidnapped, or suffering severe bodily injury. If a weapon was used, that's the next one. If the defendant committed the assault with another person, if there were more than one person that was involved, if a date rape drug was used, okay, if that was used, that makes it aggravated. If the victim is younger than 14 years of age, or if the victim is disabled or elderly. So generally, a sexual assault charge is a second-degree felony. A second-degree felony is punishable by a minimum of 2 up to 20 years in prison and up to a $10,000 fine. If that charge is elevated to a first-degree felony as an aggravated sexual assault, now you could be looking at a punishment range of a minimum of 5 up to 99 years or life and up to a $10,000 fine. So aggravated sexual assault is a first-degree felony. And so that's important to know. And by the way, if it happens more than a few times, instead of if you talk about aggravated sexual assault of a child, if it happens multiple times, you could be talking about continuous assault, sexual assault. And if that's involved, you could be looking at literally a minimum prison sentence of 25 years up to life, if that ends up being the charge. So those are just a few of the things to know. So understand this. There are a few types of defenses that you could put in play on this. One of the first ones you can do is if you didn't do anything wrong and this individual is claiming that you assaulted them, well, first thing you can do is if you can provide an alibi. What if you were somewhere else? If you had proof that you were somewhere else at the time that this individual claims this assault took place, that's going to provide an alibi. And remember, the state of Texas must prove each and every element of sexual assault beyond a reasonable doubt, okay? Well, how do you prove an alibi? Maybe you have some proof of receipts or statements, or you had somebody who was with you. These are things that all could potentially provide reasonable doubt on your case. The next one is consent. Now, this applies more on the sexual assault charge between two adults than it does about anything having to do with a minor, because consent is not so much an issue there. But it's important to know there are many instances where two people are just fine with this sexual interaction that takes place, and then the individual that is being charged had no idea that the other person was not interested in that contact. And in fact, the first time they hear about it is afterwards. Sometimes people refer to that as buyer's remorse, right? And what that means is, well, I was okay with it at the time, but after everything was over with, I didn't really feel okay about that. And that is not something that establishes a lack of consent. Consent is governed and determined at the time the incident occurred, not after the fact. So that's very important. So that's number two. Number one is an alibi. Number two is that there was consent. Consent did actually exist. Now, the next example is, what if the individual being charged was not more than 3 years older than the victim, and the victim was 14 years or older and not prohibited from marrying the defendant? Some people call this Romeo and Juliet law. The Romeo and Juliet law is one that basically says, look, if you have two people within 3 years of age within each other, then that sort of situation can actually act as a defense to something being not being consensual and therefore being a sexual assault, okay? And then we also talk about one of the other examples is, and this is rare, but we have seen it happen a few times, the defendant was actually legally married to the child. They were literally married according to the Texas law that they were permitted to do that. And so then the other one was maybe the defendant was providing, and this is rare, very rare, but the individual may have been providing medical care to the child and there was no contact or penetration occurred of the child's mouth or any other sexual organ by the defendant's mouth or any sexual organ. So listen, normally a lot of people can feel very overwhelmed by this. They can say, what am I supposed to do? How do you prove a negative? It's just this person's word. There's no physical proof of what happened. And that can be frustrating. Sometimes it's almost better if there is physical proof. If there is DNA, that DNA samples can be compared and they can be analyzed and determined whether or not the DNA matches the individual that's being charged. And obviously, if it does not match the individual being charged, you're talking about a very strong case of reasonable doubt. Okay, now please understand, jail time is not necessarily mandatory for some sexual assault charges. Non-consensual sexual contact against an adult where there is no penetration or physical injuries falls under Texas Penal Code, Section 22.01A3, and is called assault offensive contact. Now, there is a distinction to this called indecent assault, where it's called the groping statute. That makes it a Class A misdemeanor, and I won't get into that now. I'll do a separate video on that. But the important thing is to know that not all types of sexual contact are felonies. Not all of them involve having to look at a prison sentence. So maybe you're looking at this video and you're saying, okay, I had a detective call me. What am I supposed to do? Well, number one, you need to act quickly and you need to act appropriately. Think very thoroughly before you make a decision about having an actual conversation with the detective. Number two, call an attorney. You need to have a consultation with a criminal defense attorney who can provide you more specific guidance on what your next steps are because of where you stand right now if you've received a phone call from a detective. The bottom line is sexual assault investigations are aggressive. You need somebody on your side. If you are facing a sexual assault investigation in the North Texas area, don't hesitate to contact the Hampton Law Firm at 817-877-5200. We'll be happy to provide you a free case consultation, go over what your options are, and see if we can be available to help you. Thanks again for joining us. I promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below and I'll be happy to send it over to you. And I hope you've enjoyed this video. If you have, subscribe to our YouTube channel, like this video, and we'll continue to send you more great content just like this. Thanks again. Have a great day.